Hello, everyone. Welcome to Due Process. This is Trevor Wadden. Today I'm speaking with Eric Gottardi, QC. Eric is a lawyer and senior partner at the renowned Vancouver law firm Peck & Company. Eric and I will be discussing his role as counsel in the seminal case R.V. Jordan, the 2016 Supreme Court of Canada case that completely changed the landscape of Canada's criminal justice system with respect to unreasonable delay and the right to be tried within a reasonable time. By way of further background, Eric obtained his law degree from Queen's University. He then worked as a law clerk in the Court of Appeal of Ontario before being called to the bar in 2003. Eric has gone on to become one of Canada's most experienced litigators in several areas, including criminal law and extradition work. He has appeared in all levels of court, including several appearances in the Supreme Court of Canada. Eric has served as chair of the Canadian Bar Association's National Criminal Justice Section. Through his work with the CBA, Eric has testified as an expert witness on criminal law policy and legislation before parliamentary committees in both the House and Senate. Eric was appointed as Queen's Counsel in 2020 for his contributions to the justice system in British Columbia. Eric regularly contributes to legal education, appearing as a speaker for universities and other professional organizations. He is also the author of numerous papers and currently serves as the editor of the newsletter Charter of Rights and Freedoms, a publication through Thomson Reuters. Eric, it is great to have you on our show. And again, I know how busy you are and with your caseload and schedule, so we truly appreciate your time.
Thanks, Trevor. I'm happy to be here.
So I do want to maximize our time together here today, Eric, so we'll jump right into it. And the main focus of our conversation today will be on unreasonable delay and specifically Section 11B of the Charter of Rights and Freedoms. And this right holds that anyone charged with an offense has the right to be tried within a reasonable time. Before we talk about the specific circumstances of the Jordan case and the Supreme Court of Canada's decision and the framework outlined in that case, I'm wondering if you could tell us why Section 11B of the Charter, namely the right to be tried within a reasonable amount of time, is such an important right in a democratic society that values the rule of law.
Yeah, sure. So it is really one of the foundational procedural rights in the criminal law. And, when we started kind of digging a bit deeper into the section in preparation for the Jordan case, we kind of went right back to the historical roots of the charter right. And it's really one of the few rights that you can trace, all the way back to the Magna Carta, actually. This idea that even the king, there had to be some limits on his or the queen's ability to put a subject in jail and hold them there, and is linked to other concepts like habeas corpus, and the ability of the state to hold you in custody while you await some kind of process and trial. And so there was an obligation on the state to not simply put you in the tower for the rest of your life, but to bring you before the courts in a reasonable amount of time, and not to simply let you languish in custody. And so those were the historical roots of the right, and it's seen it in different iterations of the right, as I say, all the way back to the Magna Carta, through the Bill of Rights, and now into the Canadian Charter of Rights and Freedoms. And so it is fundamental, and yet it's one that's often kind of looked down upon and misunderstood perhaps by members of the public sometimes, and even members of the law enforcement or even members of the court sometimes. So it's an important section of the charter with a complicated history.
And this misunderstanding around this right, Eric, is this associated to the maybe misconception that it's allowing certain people that have possibly committed serious crime to go free?
Yeah, that's exactly right. It's this notion that people accused of crimes are not actually interested in a speedy trial. They're interested in, ragging the puck, to use a, hockey analogy, dragging things out on the off chance that they might be able to mount a motion to dismiss their case based on their case having taken too long to get to trial. It's a very odd inclusion into the kind of foundational fabric of the jurisprudence that was interpreting the charter section in the early years after the charter came out, kind of arising from a few observations by kind of anecdotally a former prosecutor, now a very renowned judge, who'd written a paper one time that observed that maybe defense counsel weren't always interested in moving things along as quickly as possible, and judges needed to be on guard and careful that the accused wasn't playing any role in stretching out the proceedings in an effort to defeat the charges.
The criticism, rather, is that from the victim side, is that we're potentially allowing people to have their cases tossed or stayed. It's not paying enough respect to the victims. But why is it more beneficial for victims too to have these things dealt with efficiently and in a reasonable amount of time?
Yeah, well, that's a great question because one of the things that we tried to point out to the court in Jordan in arguing for a change to 11B and how the courts dealt with it was that there really is a societal interest in, kind of a robust understanding of the Section 11B protections. The speedy trial right really can provide a bit of a health check on the system. And if cases are taking too long to get to trial from the date when charges are laid, it can be kind of symptomatic of other problems like a lack of judges or lack of courtrooms, lack of resources being invested by provincial or federal governments in the system, cause all sorts of other problems. And so people focus on the headline, accused, whatever, insert the crime, goes free, walks free. But that's the one kind of immediate negative consequence. The other consequence is a very clear message being sent from the courts to Parliament that something's not working right, and that either there needs to be an amendment in the law, or a greater investment in resources in the system. There's it's a bit of a way for the courts to send a message back to Parliament that something needs fixing. And that's an important dialogue. It's an important power of the courts. And it's a fundamental right that any of us that might be accused of a crime enjoys, that it won't hang over our heads for 5 years and before we get a chance to have our day in court and prove our innocence. So it's an important right. And there is the unfortunate consequence to the victims in a particular case that they don't see their case dealt with on the merits. But when a problem rises to the level where a case has to be thrown out, the court often takes the position that the problem has become bigger than any individual case, and that there's a problem in the system that needs to be addressed. And the unfortunate consequence of that sometimes is that the individual case is not going to be decided on its merits.
And I want to now turn to discuss the timelines and environment that existed prior to Jordan in 1982 to 2016. I know we have to try to narrow the focus here a little bit because, like you said, this right does go back hundreds of years and be a pretty long podcast if we focused on the history of the jurisprudence here. But I appreciate it's no easy task. But for the purpose of the show, we'll try to focus on the Charter era generally, and I'll ask, how was this Section 11B right treated by the courts prior to Jordan? Was it one that was a strong right or one that was lacking teeth?
Well, I think there's some variation province to province in how often cases would be raised and dealt with. And in the bigger urban centers, sometimes there would be legislative changes that would lead to an influx in cases that would kind of crowd the court dockets and cause problems. Or in smaller, kind of much less resourced, jurisdictions where you might only have one resident judge, those systems, even though there wasn't a high volume, comparatively speaking to the larger jurisdictions, they could have problems as well. And in the early 90s, there were a couple of cases, Moran and Ascoff, where the Supreme Court of Canada set out the approach to how 11B should be dealt with. And in the immediate aftermath of Ascoff, for example, the first case, there was a bit of a hue and cry went up from the public, because as a result of that case, there were hundreds of cases that were immediately stayed because the court had said it had kind of put in timelines, but they weren't hard ceilings. They were just kind of guideposts about how long it should take a case to get to trial in a one stage proceeding in provincial court, and how long it should take to get to trial in a two stage proceeding in a superior court. And if your case took longer than that, then you were entitled to make an application for a stay of proceedings to have your case thrown out because your trial had taken too long. But there was a very complicated test, where the judges would look at this case, case by case. They would look at the inherent time requirements of the case. Was it a very complex murder case, or was it a simple drug possession case or a trafficking case? What were the actions of the accused? Had the accused tried to prolong the case? What had the Crown done? what were the limitations of the institutional resources. That was a concept called systemic delay, and then there was institutional delay. And so there's a big long list of factors that the courts had to look at, and it involved a very microscopic and mathematical exercise where judges would have to look at maybe 24, 36, 48 months of time and start subtracting weeks and days and months here and there based and label them different things. And at the end of that very long, painstaking exercise, they then would decide, how much kind of unforgivable delay there was left. And it was very confusing. It was very time consuming for judges. It was kind of described as the bane of all judges' existence. And from counsel's perspective, or from someone charged with a crime, from the client's perspective, at least in my experience, there was very little chance of success ultimately in persuading a judge that the case should be thrown out, even if there had been quite long periods of delay. And seemingly in the years following Askoff and then Moran, you just kind of saw longer and longer periods of delay being forgiven by the judges. And new labels being applied, or new heads of conduct being forgiven and kind of wiped away. And so that was kind of what led up to and set the stage for the Jordan case, was this sense in the bar, certainly at least in British Columbia, but I know in other parts of the country as well, that 11B had kind of become the black sheep of the family, of the charter family, that you couldn't, it wasn't worth bringing the motion. I would dread when a client would come and say that they wanted to make an ask off or a delay motion, and that was kind of the only thing that they had going for them in their case or their appeal, because I knew it was largely going to be hopeless. So that's kind of where things were at least from my perspective, heading into the time that Jordan got argued.
So the Askoff and Morin, and you can tell me if I'm being too simplistic here, Eric, but in the Askoff and Morin approach, there were all these classifications for why these delays were occurring. And my understanding is it really came down to the prejudice that the accused would suffer, right? They really needed proof or evidence that there was an actual prejudice to the accused.
Yeah, that's a great point. Prejudice was a huge component of the pre-Jordan framework, and there was concept of inferred prejudice, and then there was the concept of actual prejudice. And in some of the early cases after Moran and Askoff, courts seemed willing to infer the fact that if you had to wait 3 years for your trial, that you were just inherently going to suffer prejudice from that. And over the years, the courts in different provinces began to put less and less weight on the concept of inferred prejudice, or they seem to show less willingness to simply infer prejudice from the reflection of time. And they put greater and greater obligations on the accused person to actually demonstrate some concrete prejudice that they had suffered. And they kind of said, look, everyone charged with a crime has some impacts on their job or their life. There's some stigma that's attached. We're not going to count that stuff. You've got to show us above and beyond that, what prejudice have you suffered because it took 3 or 4 years for your trial to come around? And so, you had to show that one of the witnesses that you wanted to call had died or moved away, or some of the evidence that you wanted to have tested forensically had been thrown away or decomposed or something. Like, you really had to point to something concrete that arose from the delay if you wanted to have any reasonable prospect of success.
So when the application was actually, I appreciate it was difficult, but when it was actually successful, was the remedy still a stay?
Yes, yeah. There'd been kind of some early discussions amongst some of the court decisions early on about whether or not there was any other remedy available under the charter that would kind of be a meaningful remedy to the fact that you had lost time essentially by the violation of your right, and ultimately the court concluded that a stay was really the only appropriate remedy. It couldn't exclude evidence, it couldn't award damages necessarily. It couldn't do anything other than say this case just took too long, and so we're going to end this prosecution. Now, I think it's an open question these days in the current day of whether or not the courts may revisit that remedy. But so far, since the inception of 11B, the stay has been the remedy that flows from a breach.
Is maybe a reconsideration like financial, you mean, or just another like adjourning and other possible remedies?
Yeah, like when you bring a Section 7, Charter Section 7 abuse of process motion, you really only get to ask for a stay of proceedings in the most egregious set of circumstances, right? They say it's reserved for the clearest of cases. And so the courts will always look to see if there are any lesser remedies that the court could provide to the accused to remedy the rights violation. So the courts are always looking for whether or not a lesser remedy would kind of do the job. And 11B is the one of the very few contexts where there really is not a particularly satisfactory lesser remedy than a stay that's been adopted by the courts thus far.
Okay, so we have this background leading up to Jordan where it's difficult to get 11B application or a successful one. There's regular delays in getting things to trial. Was there a sense in the legal community, from your experience, Eric, that these delays were becoming a real issue in the criminal justice system and that something had to be done?
Yeah, I think so. I mean, you would see these things would be a bit cyclical, at least observing them here in British Columbia. In some of our busier courthouses in Vancouver and in Surrey, in the 5 to 8 years before Jordan, it wasn't uncommon for your trial to take 3 or 4 years to get to trial in the really protracted cases. And the courts were very busy. The delays for just to get any trial on were over a year just as a starting point. And so there was a bit of a bubble. And so what happens in those cases, you start to see a few of these cases, these 11B cases kind of bubble up to the surface. And so you'll see an impaired driving case get thrown out. A couple months later, you'll see maybe a robbery case get thrown out, and it'll get progressively more serious. And then there'll be some headlines and some news and some pressures put on the government. And then 4 new judges are appointed, and the backlog kind of gets dealt with a bit. And so that was the case in BC. We'd had a real problem, and that's what had led to some cases being successful in making their way up to our Court of Appeal. But, at our Court of Appeal level, the court had really ratcheted up this concept of prejudice that you brought up earlier, Trevor, and they'd almost eradicated the concept of inferred prejudice and said that the accused had to really show a very significant amount of prejudice if these things were going to be successful. And in Ontario, there had been some cases where judges had said, look, defense lawyers basically needed to take their personal calendars and put all 2 years of their trial schedule into the record and note every single week that they might be available if they wanted to demonstrate that they were serious about getting a speedy trial going. And so you started to see these kind of judicial roadblocks being thrown up to deal with a bit of an onslaught of these motions being brought. And so there was this sense that, and I can't speak for others' kind of frame of mind, but in the time we were preparing Jordan and we took Jordan up, it certainly was our view that the court had to do something, that they had to come in and try something different because the system that we had just wasn't working. But despite the court's clear directions in Askoff and Moran that lower level judges were just continuing to find ways around those rules and forgive longer and longer delays. The Crown even argued once we got to Ottawa that if the accused couldn't show any prejudice, then it didn't matter if it took 5 years to bring the person to trial. And that's one of the reasons why we tried to say, well, it's not just the accused who has an interest in a speedy trial. It's the victim, it's the witnesses, it's society, right? You want to see these cases dealt with while you still remember them, while the witnesses still remember what happened, while their memories are fresh. There's a real interest in all of our parts to having trials that get concluded within a short period of time. So there was I think there was a frustration level or a sense that something had to give in how the right was being litigated before Jordan.
So when you guys got to Ottawa, did you appreciate that this could be as impactful as it has turned out to be?
No, to be really honest with you. Like I said, when my partner kind of walked down the hall and asked me to take on the Jordan brief, I didn't want to do it, even though it was a chance to go to the Supreme Court of Canada and argue it. I had no idea why the court had granted leave. I didn't have any high hopes that they were going to kind of adopt a brand new, completely different approach. And so when we went to Ottawa, we went there with a very modest goals. We wanted them to overturn a couple of decisions from the BC Court of Appeal that had kind of done away with this concept of inferred prejudice. We wanted them to overturn a few decisions from Ontario that had put, we thought, too much of a burden on defense counsel to, show their availability at all times in order to be able to argue for a violation. And so we didn't go to Ottawa with a brand new suggested test or regime. It was really just a few modest goals places that we'd identified in the case law that we thought were kind of operating a bit unfairly. And we wanted the court to kind of reaffirm the importance of 11B in the charter landscape. So when we got to Ottawa and the hearing started to unfold, we were very surprised at kind of what took place.
And we'll get into that here momentarily. So your firm, was it involved just for the appeals?
Yeah, so our firm took over, I think, at the tail end of Mr. Jordan's trial case. Essentially, we thought it was a situation where there wasn't much of a defense to the merits of the case. We brought an 11B motion at the trial level. It was unsuccessful. Appealed it to the Court of Appeal level. It was unsuccessful in the Court of Appeal, and then had applied for leave to the Supreme Court of Canada on the 11B issue. And that's when leave was granted. And so a couple of the lawyers in my firm, Richard Peck and Kathleen Bradley, had been counsel for Mr. Jordan in the lower levels. And when it came time to do the leave application, that's when Richard asked me to take over the file.
And just the actual merits of Mr. Jordan's case, can you just give us a brief summary of the circumstances of his charges and just the length it took for the trial to happen?
Sure, I'll do I'll do my best.
If it's easier, Eric, I can read a brief little thing I prepared, and you can tell me if I'm accurate.
That's probably better. I mean, otherwise we'll see the true merits of we'll see the effect of delay on memory.
Yeah, well, I have an interview about memory fallibility tomorrow, so that could.
Perfect.
But no, so my understanding is that Mr. Jordan was charged in 2008 for his alleged role in a dial-a-dope drug operation, and his trial was scheduled to end in 2013. And he therefore brought an application under 11B of the charter due to the delay, which would have been about nearly 50 months from the day the charges had been brought to the end of his trial. And the trial judge agreed there was a delay, but more or less found that he was unable, as we discussed, to show that there was any actual prejudice to him, because I think he had some unrelated charges and some conditions already pending or in the system to begin with. And there was no evidence that witness memory or any other evidentiary issues would prevent him from making full answer and defense, which is my brief summary of the case.
Yeah, that's right. And he was charged with several co-accused at the beginning who were alleged to be involved in this dial-a-dope operation over the course of the next 12 to 18 months. A few of them kind of dropped off and pled guilty, pled out. And by the time of his 11B application, near the end of that process, I think he was either one of two left standing or maybe the last man, standing in terms of someone with charges still extant before the court. And you're right in terms of the timelines. It had taken almost 5 years. And just to give your listeners a sense of the disparity and the confusing nature of these tests before Jordan, when we got to Ottawa and had done all the subtracting exercises that we said applied, we thought there was about 42 months of unexplained delay or delay that could be attributed to the system itself. But when the Crown had done its math and subtracted what they thought should be subtracted under the Askoff and Moran tests, I think they said that there was like 11 months that was appropriate. So pretty huge disparity between 42 and 11 months from two sets of lawyers applying the very same test to the very same set of facts.
Okay, yeah, that's pretty broad in terms of difference of opinion there. So, with those basic facts, we know Mr. Jordan's position going into the Supreme Court of Canada. There were also three interveners in the case: the Attorney General of Alberta, BC Civil Liberties Association, and Criminal Lawyers Association of Ontario. And just briefly, Eric, did they agree that a change needed to happen in terms of the delays that were in the criminal justice system, or were they there to try to stand up for the status quo?
Yeah, I mean, in the most general sense, the Attorney General for Alberta was taking a fairly aggressive or strident position, as I recall it. Really, all it should always be about prejudice, and if you couldn't show any prejudice, then the delay could really be as long as you wanted it to be, because there was no harm, no foul, essentially. The interveners on the defense side, the BC Civil Liberties and the Criminal Lawyers Association, were both kind of, they didn't, neither one really commented on Mr. Jordan's case per se, but were raising their own complaints or issues with how Section 11B was being dealt with in British Columbia and in Ontario. And Frank Addario, who was counsel along with Aaron Dan, I believe, for the Criminal Lawyers Association, did a great job in their submissions to the court that there was a big problem with how this charter right was being vindicated on a day-to-day basis. And and Penn had picked up on some of the comments made by some of the justices in the course of the hearing that maybe the court was open to a fairly substantial change, and was a little bit worried, actually, that they might change too much. And so, for the remedy question that we talked about a moment ago was one area where both myself and Mr. Addario kind of cautioned the court to not do anything or change anything about a stay being the only appropriate remedy in Section 11B cases, because we just hadn't had a chance to argue those issues before the court.
So you go to the Supreme Court of Canada, and obviously the decision comes down, and the majority of the court definitely transformed the way that the Section 11B analysis was to move forward. And at the heart of the new framework that the court established was a presumptive ceiling, or presumptive ceilings beyond which delay from the charge to the actual or anticipated end of trial is presumed to be unreasonable unless there was an exceptional circumstance to justify it. Can you just take us through the timelines or these presumptive ceilings that the court established in Jordan?
Yeah, sure. And so this concept of kind of presumptive ceilings was something that came up in the course of the hearing. And in fact, I remember it was Justice Moldaver had asked me a question in the course of my submission, complaining about, how 11B was too confusing and overly complex. And he had simply said to me, "Look, Mr. Gottardi, wouldn't it be, better or easier if we had a kind of a drop dead date, like a ceiling beyond which point we would just simply say the case took too long, and that would simplify things? Wouldn't that be better than what we have now?" And it was a surprising question from a member of the court. And so I was a bit kind of flip in my response. I basically said, "Well, I've only thought about it for about a minute, but yeah, I think it would be." And he said to me, "Well, what do you think about 30 months?" And I kind of said, "Well, I don't know. How about 24?" and that was kind of the extent of the back and forth on this whole concept of ceilings or kind of drop dead dates. And so when we saw it materialize in the reasons for judgment, when the decision came out in July of 2016, needless to say, we were pretty shocked. And so the court had settled on 18 months as a hard stop deadline for cases that were going to be tried in the lower courts, in the provincial court. And for the more complex cases that required a two-stage proceedings, the Crown had 30 months to get the case from the date of charges to the conclusion of the trial, which is a long time. I mean, it's just under 3 years, but it was important that the court had said that those time periods were meant to include a whole bunch of things that happen in almost every case. The intake period, the time it takes to get, kind of organize the file, get the disclosure out to, if it's from the police to the Crown, and then from the Crown to defense, reasonable time for the defense to review the material and analyze the case and come up with a defense. that was all time that the court said was built into these 18 and 30-month time periods without having to get into any toing and froing about who adjourned case on what date for what reason. All of these things that tend to happen in a case are just kind of baked in to this time period. And short of exceptional circumstances, and they gave some examples like counsel getting sick or the judge getting sick or a death of a witness or something fairly exceptional and fairly unique, those things would be taken out of the equation. And then the other cut out from the analysis of the time period was any time that the accused themselves caused the delay. So, accused person fires their lawyer and it takes them 2 months to get a new one. That's not time that's going to count against the Jordan clock. That's time that's solely the fault of the accused person. And so those kinds of time periods, those kinds of delays are going to be subtracted from the analysis. But the idea was to really try to simplify it and just make it clear, no matter what, these cases have got to be dealt with in these time periods. And if they don't, then they're going to be presumptively unreasonable. The accused doesn't have to demonstrate prejudice anymore. The court's just going to assume that there's prejudice, and they're going to, as a matter of law, find these delays to be unreasonable unless the Crown can explain the reasons why the delay that exceeds these time periods should be forgiven.
And your exchange while you're at the Supreme Court of Canada, where they ask you about, this drop dead point, I have seen some criticism that the court more or less invented these timelines of 18 to 30 months in their presumptive sealings. In my understanding, Eric, is none of the parties had argued for this, right? There was that exchange you discussed, but no one in the actual case had said, these presumptive sealings should be established. Here's some evidence. Here's some research to consider. We think this is a great idea. This is something that the Supreme Court of Canada, or the majority of the Supreme Court of Canada, arrived at somewhat independently from the parties, correct?
Yeah, I think that's right, and you can see that when you look at the two differing judgments in Jordan. The minority judgment by Justice Cromwell, who's a wonderful judge, seemed to be quite upset with the majority and their decision to kind of throw out the prior 4 or 5 decades of jurisprudence and just go with these seemingly arbitrary guidelines. And Justice Cromwell was critical in the judgment of the majority's approach to how they came up with these numbers. Now, in the defense of the majority, they tried to explain in the judgment that they'd gone off and done a review of cases from across the country and had come up with, kind of these what they thought were reasonable timelines. But there wasn't 100% transparency in what that research looked like, and it certainly wasn't something that was kind of raised by the parties and presented by the parties as a potential resolution. So there certainly was criticism, academic and otherwise, about the court's decision to do this. Now, the court also bent over backwards to avoid a situation like happened after Askoff, where hundreds of cases were immediately thrown out, by creating what many thought was a bit of a confusing kind of grace period that they called the transitional period, where judges were going to be able to apply the old test and the new test, and then kind of decide whether or not a stay should flow, because the cases that were coming immediately after Jordan were going to be in excess of these presumptive sealings. And so the court built in a bit of a safety net there for police and Crown and some of these cases, and which was largely successful. There was not a huge flood of cases that were thrown out. There certainly was an increase in 11B applications, there's no question, and there was an uptick in cases that were successful, but nothing on the scale of what happened after the Askoff decision.
Okay, and the majority did make clear that the reason for the presumptive sealings was to show that it wasn't just going to be business as usual. They wanted to, I think, put the players in the justice system on notice that things and serious changes needed to occur, and that Section 11B was not just going to be a quote a hollow promise. So, Eric, do you agree with ultimately what the majority? Do you think it was a wise decision to put these presumptive sealings in place?
Yeah, I've never really known how to answer that question, and I've been asked it a lot. and I kind of always, I always kind of hid behind the answer of, well, time will tell. But now we're, kind of five years out from Jordan, and I think it was important. I think it was important to send a message to all members of the justice system, including and perhaps especially judges, that violations of 11B are serious. They're not an unjust windfall that clients and lawyers or defense lawyers are angling for. And so, committees were struck across the country, judicial committees partnering with the bar, trying to talk about the impact of Jordan. Seemingly, no one wanted to talk about anything other than Jordan for months after the decision came down. And there was a lot of kind of the sky is falling type of sentiment that was expressed. But that was all good in my view, because it was a system that needed a shakeup, and it was a charter right that needed some better, more robust protection. So, would it have better just to reemphasize some of the principles and stick with the same framework? I don't know. Are the presumptive sealings better? I don't know. I do think that despite the very strong language from the court in Jordan, that there has again been a little bit of slippage in the 5 or 6 years since then on 11B. And you don't have to look very far. I mean, in our province in British Columbia, I think there's only been one 11B case allowed by our Court of Appeal in the 5 years since Jordan. And that's of several that have made their way up to the court. So, there's still, and perhaps with good reason, a strong reluctance on the part of judicial officers to enter stays of proceedings in criminal cases.
Yeah, it's not an easy question to ask, but I had to ask it. So
No, I
yeah,
appreciate that,
yeah.
and I wish I had a better answer for you. It's probably an unsatisfying answer, but I think it's in the eye of the beholder somewhat.
So the real difference, if I can here, just again to try to simplify, between the Morin Askov pre-Jordan approach is that under the Jordan framework, you have these presumptive ceilings where prejudice is assumed once you exceed these ceilings. So you no longer, as the accused, have to show an actual prejudice. It's just there. It's presumed.
Yeah, that's right. I mean, from a strictly legal perspective, the two major changes were on the issue of prejudice and this concept of seriousness of the offense. And both of those concepts were ones that people in law enforcement and on the prosecution side were very concerned about in the wake of Jordan, because pre-Jordan, the more serious the case, a murder case, for example, the greater the public interest there would be in having a trial on the merits. So you were more likely to forgive a 5 or 6 year delay in a murder trial than you were in a shoplifting trial. And after Jordan, the court in Jordan made it clear the seriousness of the offense doesn't matter. An accused that's charged with a crime has a right to a speedy trial no matter what they're charged with. And that was a concept that was very concerning to many in the law enforcement prosecution side. And then the other major change, as you said, is after Jordan, the accused no longer has to prove actual prejudice. There is no evidentiary obligation on the accused to show any prejudice on an 11B application. Now it's presumed as soon as those ceilings are exceeded. Those are two major changes in the law and how the charter section is interpreted that flow directly from Jordan.
So I just want to ask a couple questions since Jordan in the years that have gone by. Courts, after the and governments after the decision were encouraged to implement more efficient procedures for case management and to get matters before the courts in a more expedient manner. And for instance, my understanding now is preliminary hearings are only held in the most serious of cases. Have you seen improvements in terms of trial procedures in getting cases before courts?
Yeah, I mean, again, and that's a complicated question, and I'll try not to ramble on about it. But certainly there have been some improvements. And there, as I said, there were committees formed immediately, and steps were taken to try to look at ways to make the justice system more efficient. But the delay, for the most part, it's a bit of function of, are there enough judges? Are there enough courtrooms to accommodate the current inventory of cases? But the real way to address delay in the court system is to look at ways to decrease the inventory of criminal cases in the system. So, that means coming up with new vehicles, new off ramps for restorative justice or pre-charge diversion. Or, I mean, in British Columbia, we almost effectively decriminalized impaired driving, which took a huge cohort of cases out of the court systems. So that bubble of delay that we had in Vancouver and Surrey had disappeared by the time that we got to Ottawa and Jordan because of those legislative reform changes just to remove inventory from the court docket. So, the preliminary inquiry, ironically and unfortunately, from the perspective of many Crown and defense lawyers, was an unfortunate casualty of this kind of post-Jordan hysteria to, rush to look for ways to improve the efficiency of the system. There was no correlation between the existence of prelims and delay. It was, many experienced Crown and defense lawyers thought they were valuable tools when they were used. And, now they've kind of largely been abolished on the altar of efficiency when really they actually weren't a contributing cause to delay in the first place. And I also find it ironic that after years of threatening to abolish the prelims under successive conservative governments, it was the Liberal government that actually abolished them. So that's one of the, from my perspective, the very unfortunate footnotes that flows from Jordan.
And I read this criticism numerous times, and we touched on it briefly near the beginning of our chat today. But the cynical perspective here is that people were concerned that more and more accused would be, especially if you're self-represented, would be intentionally trying to delay things and cause delays because then they could bring this application and the court would throw out their charges. Do you think there's any merit to that argument? In your experience, do you see that at all?
I would say that concern is largely overblown. Like in any profession, if someone chooses, you could point to, one or two individuals who anecdotally had witnessed someone adjourning a case multiple times for less than bona fide reasons. But, the reality is that, these timelines now are so long and so forgiving to the prosecution that, like I've said a few times, like 4 or 5 really significant problems would have to emerge over the lifetime of a file to get the file into Jordan trouble. And a self-represented accused or a lawyer who adjourns for a month or two here and there because, they're busy and they haven't read the file or something, and that on its own is not gonna get you there. So this idea that accused persons can just, game the system to the end result that they get a stay and get to walk away scot-free really doesn't materialize very often. But it is the boogeyman that is raised by many that are critical of these decisions. And of course, anytime there's a reported headline of a judge throwing a case out, they're always girding themselves for the inevitable public backlash that will come. And like I said before, that's part of the system. It's part of how it's supposed to work. 11B is going to tell the public that something is not going right with the system. And unfortunately, there might, a casualty might be one particular case. But if we were just to forgive that and just let things go and get worse and worse and worse, the problem is systemic and is much bigger than that, and would be a lot worse if we let it go unchecked. So that's a difficult thing for a victim or a victim's family to understand or appreciate if it's their file that's thrown out and the person who's accused of doing harm to them or their property is not going to face a court and is not going to face justice for that case. And I understand those feelings, but it becomes a bit more than just that case when you're asking a court to stay a case because of delay.
Well, Eric, you've been gracious with your time today, and it's been a great conversation. Your insights were really, again, really, really great to have, and we can't thank you enough for coming on. Are you someone that is on social media? Do you have any usernames or anything you want people to follow?
No, I'm at a bit of an old-fashioned shop, and so we've not really active on Instagram or Twitter. We've got the website there and emails on the website. So if anyone has any questions, they're welcome to shoot me a message and ask away.
Awesome. Well, we'll link your website info in our show notes with this episode. And again, Eric, thank you for joining us today.
No problem. It was my pleasure. Thanks, Trevor.